It's a pleasure to present this lecture, for judicial title and its attorneys. Um, I'm gonna give you a little overview of what we're gonna be doing today, right now. First, I'm going to, as Richard mentioned, this is a 2-credit ethics program. So I'm gonna probably spend the first hour or so discussing Rule 7.1 to 7.5 or 7.6 if you looked at the model rules. New model rules. And then we're going to then I'm going to shift things over to Brad. He's going to take the lead in discussing some of the general marketing techniques. And then we're going to come back and go over some most likely see what we could get through in terms of the recent ethics decisions. We're probably going to skip over Alexander versus Cahill because we incorporate it during the lecture. So feel free to leave questions in the chat. We'll try to get to those at certain points as well. So just a little bit of background, a little bit of history here. So back in 1983, the model rules of professional conduct were adopted by the American Bar Association. Over time, the states almost universally adopted the rules. In 2000, a comprehensive review of the rules were made. So New York State adopted these rules in 2009. And I maybe mentioned this during the course of the lecture. There was a period of time in 2007, 2008, as it was considering the rules, that drafted some new rules for New York State, and those rules were a little bit more strict. And then they were pulled back from there, and then you have obviously the rules that we've had since then. But the rules, have been modified over time by comments, by ethics opinions. Although the rules help more clearly define what is and what isn't acceptable for attorney advertising, and help to defend the integrity of the profession by establishing clear guidelines. I think that, as we alluded to earlier, it's a little less clear now as well. But I mean, that might be one of the driving forces, that and technology, why ABA overhauled its advertising rules in 2018, including deleting Rule 7.4 and 7.5. And add in a 7.6. A few states have adopted the new rules, including Connecticut, Minnesota, Montana, 7.4 only, Nebraska, 7.5 only, New Mexico, and Virginia. So if you're in one of those states, just, we do touch on a few things, but I would certainly, take a look at the rules that apply there, especially. Some states have also adopted a Rule 7.6 that prohibits a lawyer from accepting an engagement or appointment from a judge if the lawyer makes a political contribution for that purpose. So that was added. Some states have adopted that. New York has a similar rule that doesn't specifically mention judge, but mentions governmental office. So over time, the rules have been modified by states to court decisions regarding commercial speech, as well as ethics opinions and other changes. The handouts contain New York rules, Virginia rules, model rule comparisons by the states, by state, and select New York ethics opinions. Again, check your state's rules and ethics opinions. We use New York's current rules and comments and opinions for this lecture. Okay. All right. So advertisements are defined in 7.1 and 7.3. So an advertisement is a communication that is primarily designed to attract new clients. That's pretty basic. Two major exceptions, though, that I think are important to mention here, that if you fell into these, you wouldn't have to worry about the rules. One is to existing clients, and is also to other lawyers. So if your communications are only going to existing clients or only going to other lawyers, you don't have to worry about the rules. Some other key provisions: a lawyer shall not disseminate an advertisement that contains a statement that is false, deceptive, or misleading. So this is it's 7.1a. It's the first rule. It's probably the most important rule. So I think if you try to comply with this rule, you're complying with most of the advertisement rules in one way, shape, or form or another. Otherwise violates a rule. All right. So there's obviously additional rules. Truthful statements that are misleading are also prohibited. So, for example, I have never lost a case. It's truthful, but would be misleading if the lawyer settled virtually all cases handled. All right. It probably would also be misleading if the attorney is relatively new to practice. For example, an average jury verdict for a given year was $100,000. Maybe misleading if a large number of verdicts were very small and there was one $10 million verdict. Usually at this, usually when we run into that big of a problem there, most of the advertising we're doing, we are, accentuating the $10 million verdict or $10 million settlement. And in many cases, one of the techniques that is pretty common in law firm advertising is on your website to include a results page, and usually you want to include the highest result first, and then go down from there. So that usually doesn't come up too often. An advertisement may include things such as education, bar memberships and offices, practice areas, publications, languages spoken, and bona fide professional ratings. Names of clients regularly represented, provided the client has given prior written consent, including current representations. That's something that has been modified in the rule. Credit arrangements, non-legal service provided by the lawyer or firm, or by an entity owned and controlled by the lawyer or the firm to the extent permitted by 5.8, Rule 5.8. We'll talk a little bit about 5.7, not in 5.8, which get into details on this provision. Basically, 5.7 is non-legal services provided by the firm, and the 5.8 is non-legal services provided by a professional service firm. Legal fees for an initial consultation include no fee, may be advertised, contingent fees in civil matters include no fee unless recovery. There are other rules apply there, though. 7.1C, no endorsements from clients with respect to a matter that's still pending. This was overturned in Alexander versus Cahill, so you can do that. If a paid endorsement or testimonial, you must disclose that the person is compensated. That's still in play. No portrayals of a judge, which was overturned in Alexander versus Cahill. You may use actors or fictionalized cases if it's disclosed. You often will see on a TV advertisement, such as in the footer, actor's portrayal or paid actor or paid testimonial by real client or something like that, indicating that the person's been paid, or if they're an actor, or if it's an actor's portrayal. Very often in television commercials, we're using stock footage as well, and you probably don't need to, but you could also use a disclaimer there saying that's an actor's portrayal. Advertisements shall not resemble legal documents. Okay. No nicknames, monikers, mottos, or trade names that imply results. Heavy hitters, big hit. This was addressed in Alexander versus Cahill. Ads may contain statements that are reasonably likely to create an expectation of results. So they may contain such statements. It may contain a comparison of a lawyer's services to other lawyers. It can contain testimonials of current or former clients. It can contain statements describing the quality of a lawyer's services, provided that they're factually supported at the time of dissemination. Okay, they're accompanied by the disclaimer, prior results do not guarantee a similar outcome. With respect to a matter that's still pending, provided that the client gives informed consent in writing. Okay. 7.1 in the comments, descriptions of the characteristics of a lawyer or firm that are not comparative and do not involve results are permissible, such as hardworking, dedicated, compassionate, but comparative descriptions must be factually supported, such as best or most experienced or hardest working. So you cannot use those because you cannot factually support them. So obviously there's a lot of terms in between. The important thing is to be able to factually support them. Claims about results that cannot be factually supported may not be advertised, such as big dollars, most money, or we win big. Again, sometimes there's a middle ground that's a little less clear. How about trade names that cannot be factually supported? Again, that's usually where if you're talking about past results or implying results, then you can't use them. But if you're not necessarily implying results, then you could use them. Attorney ratings are permitted, provided they contain the past results disclaimer. However, they must be bona fide, unbiased, and undiscriminatory. They must be based on objective criteria or legitimate peer review, and unbiased by the rating service economic interests. They must fairly consider all lawyers within the pool. All right, so this is one of this is one of my pet peeves. This rule, I feel, this is an area that I would suggest that the Martindale Hubble ratings or super lawyer ratings, would seem to be permitted, since super lawyers does give the opportunity for people to be rated among all lawyers. So, but local newspaper competitions on the other end of the spectrum that are like best of, or they're a pay to play type provision where you're paying for advertising to get the award or rating, let's say, or something where there's voting. So on Long Island, I think some people are here. You'll see like the Best of Long Island Awards. It's selected by daily voting, where respondents are encouraged to vote daily. So obviously, um, this is not peer review. It doesn't seem to be objective criteria, especially if you could manipulate the voting. So I would suggest that those are not, something that could be advertised, but a lot of attorneys do. How about best lawyers and other promotional badges? So you have to look at the selection criteria. One of the ethics opinions talks about that, and it's from the lawyer's determination that it's bona fide. So if you're going to potentially a look at a rating service, or look at something like a badge, or participate in a best lawyers or something like that. It's up to the lawyers to look at the selection criteria to make sure that it has objective criteria. It's probably not going to have legitimate peer review. 7.1F, all ads other than radio, TV, directory, newspapers, magazines, or other periodicals shall be labeled attorney advertising on the first page or the home page. It's not necessary where it's self-evident. If it's in a brochure or a postcard, it shall appear therein. And we'll get to that in 1 second. But we were asked a question in the last time we presented this lecture as to whether or not you needed the attorney's address in the ad, and you do for most ads. And I think the question specifically was a billboard. Whereas you might not need the attorney advertising label on the billboard, you still would need the attorney's address. Okay, so if it's in an email, attorney advertising shall appear in the subject line. I very rarely see it, and see this in attorney emails, and so it doesn't say where in the subject line. It could be at the far end, the right side of an email after your regular subject line in there. You obviously can include attorney advertising in the body of the email, and the prior results disclaimer, and other disclaimers as well regarding the content. But if your email is advertising, in most cases it's going to be, such as for an e-newsletter, and unless it's strictly educational or not for the purpose of gaining clients, then you would need the attorney advertising label in the subject line. Again, very rarely do I see an attorney email that has it. Okay, so again, in 7.1, the comments, attorney advertising label, not necessarily obvious advertisements, including TV, newspaper, and billboard ads. Okay. And sometimes, and TV is pretty easy to comply with, because in TV, you just usually put the attorney advertising disclaimer on like the last screen, where you have contact information as well as the prior results and any other disclaimers you might need. But sometimes in radio, it's definitely more difficult. So if you have to talk about whereas the attorney advertising label may not be required, is not required there. The prior results label may be required if you're talking about results, and that's going to take you a second or two to communicate on the radio ad. Current clients are excluded from the rules. This is interpreted more broadly than current client for conflict of interest purposes. Former clients, if germane to early representation, are excluded. Topical, we touched on this just a few minutes ago. Topical newsletters, client alerts or blogs intended to educate recipients about new developments in law and not considered advertising. So in your e-newsletter, if you had strictly information in there, educational information, it may not qualify as an ad and therefore would not require the attorney advertising disclaimer. But in most cases, most e-newsletters are going to talk about, they're not just going to talk about education. They're going to talk a little about the firm, may talk about the firm's results, may profile an attorney, and very often they become mixed between advertising and not advertising, and you would have to then comply with the advertising rules. Okay, and that's what we just said here. That if the newsletters, alerts, and blogs that contain information predominantly about the lawyer or firm would generally be considered advertising. Redistribution of a newspaper article is advertising if the primary purpose is to obtain clients. You must just comply with disclaimer requirements and correct misinformation. So I don't recall seeing an opinion regarding this or anything rules regarding it, but with respect to blogs, sometimes blogs are sitting on a website for a long time. So whether or not you would be required to, the question would be whether or not you're required to update a blog article if that is no longer accurate. But I would certainly include in your footer, in disclaimer on the blog articles that in addition to you can even have the attorney advertising, you can have the prior results disclaimer in case one of your blogs talks about a case or something like that. Also, say that information contained in the blog is for education purposes only. You should contact an attorney if you have a specific question, and so on and so forth. You've seen those disclaimers. But I would also say that the information contained therein may become dated and may no longer be accurate. So again, it's important to not apply to your individual situation. Promotional items, mugs, T-shirts, etc., are not considered advertising. 7.1G, no pop-ups or pop-unders on websites. That was overturned in Alexander versus Cahill. No meta tags or hidden computer codes that, if displayed, would violate a disciplinary rule. So the rule applies to, you can't have, here's an example, like New York or NY personal injury specialist. 7.4 prohibits the use of the word specialist. So not only can you not have that on the visible page on your website, you cannot have it in the keywords or the meta tags to allow it to potentially come up better in search engine results because that would violate a rule. So it's not only what you see, but also what's hidden in the computer code. 7.1H, all advertisements shall include the name, principal office, and phone number. But if you have a virtual office, you don't, an internet address, website address is sufficient there. Okay, so principal office may be complied with by listing where substantial work is performed. And we'll discuss, hopefully we get to it in the opinions. Internet address may satisfy this for a virtual office. 7.1J, advertisement of fees. When advertising fixed fees, you must have available to the public a written statement describing the scope of each advertised fees. Those fees shall include all that is reasonable and necessary under local custom. Advertisements shall be approved by a lawyer or firm and retained for 3 years. Emails or computer access, such as a website, for 1 year. Websites must be retained for 1 year from the time of publication, redesign, or extensive comment change. The rule also says that a site shall be preserved no less frequently than every 90 days and retained for 1 year. So you could see, that it could become a little bit difficult to comply with this. What we have done in the past to help our clients comply with this rule is that we would do an automatic save to quarterly to our websites on our server. And that would give a file and it would sit there for 4 quarters for a year to comply with this rule. So if your average 7.1L, if you're advertising an hourly rate, a fixed fee or fee schedule, you shall not charge more than the fee advertised unless the client agrees in writing that the service is to be performed when not legal service referred to or implied in the ad, and that a different fee arrangement shall apply. So it's important to include that potentially in your retainer agreements if you're engaging in advertising the fees. So this is one of my favorite rules, 7.1 M and F. If you're advertising a fee, you'll be bound by that fee for a period of time, depending on the frequency of the ad. So if it's more than 1 month, then no less than 30 days. So if you're doing like a weekly advertising, like a weekly penny saver, or weekly newspaper, no less than 30 days. If it's a monthly or longer, then until the next issue. If there's no succeeding issue, then a reasonable time, but no less than 90 days. If it's like broadcast, like TV or radio, no less than 30 days. Another example would be the phone book. There may be still a few of those out there. You would be bound until the next issue. Or if there's no more phone books and that's the last phone book, then it would be a reasonable time. But if the phone book was published on a yearly basis, then you're probably going to have to keep that advertised fee available for a year, since that would probably be considered reasonable. A lawyer shall not give anything of value to representatives of the press, radio, TV, etc., in return for publicity. What about Super Lawyers magazine? Well, I was looking at Super Lawyers magazine last time it came out, and I noticed that every page has the attorney advertising disclaimer. So there's really no effort being made to indicate that publication is a bona fide journalistic publication. It's strictly an advertising vehicle, and every page has the disclaimer on there, and I believe probably the prior results as well, so that whether it's an article or an ad, everything's considered an advertisement there. All ads must also comply with 788(3) of judiciary law when discussing fees. So basically that you must not state or imply that the lawyer or firm's ability to advance or pay costs is unique or extraordinary unless it can demonstrate that its fees are objectively unique or extraordinary. Doesn't prevent you from discussing fees or expenses, just can't state or imply that they are out of the ordinary. Okay. A lawyer may accept employment that results from participation in activities designed to educate the public, to recognize legal problems, to make intelligent selection of counsel, or to utilize legal services. A lawyer may speak publicly or write for publication on legal topics, so long as the lawyer does not undertake to give individual advice. Okay, so that's good for your disclaimers. Public relations programs are generally not considered advertising unless the recipients or attendees are expressly encouraged to hire a lawyer. Talks and write-ins by lawyers for non-lawyers, attorneys should caution them not to attempt to solve individual problems on the basis of the information contained therein. So that's your disclaimer for public education information. Nonprofit sponsorships are not considered advertising. There is they can even contain information about the firm, contact info, and practice areas. But just going back to that one, there is an ethics opinion, in case we don't get to it, that discusses this is from December 14th, 2023. That opinion made a distinction of a attorney being listed on a nonprofit website that provides information for victims of toxic chemicals. The sponsorship was okay, but it was not okay to be listed on a page that discussed legal options, so that would constitute a recommendation So again, it's okay to have to be a sponsor, to be listed on the website of the nonprofit, but not on a page where it discusses legal options, because that goes across the line of becoming a recommendation. And a lot of the opinions from the last couple of years deal with lead generation websites. Also deals with some advertisements that regarding the issue of whether or not the website makes a recommendation or an endorsement of the lawyer or firm, such as Advocates from a few years ago, and that would that's considered not permissible on the advertising rules if the site makes a recommendation, or in this case, the sponsorship seems to be making a recommendation. Okay, so now we're going on to Rule 7.2. 7.2A, a lawyer shall not compensate or give anything of value to a person or organization to recommend or obtain employment by a client or as a reward for having made a recommendation resulted in employment by a client except. So this is a good segue to Rule 7.2. Okay. You may refer clients to non-legal professional service firm pursuant to a contractual relationship in accordance with Rule 5.8. However, such referral shall not include monetary or other tangible consideration of the share in a legal fee. So you can make a recommendation as a law firm to a non-service professional firm such as an accountant, but there cannot be a sharing of legal fees. A lawyer may pay fees or dues charged by a legal assistance organization or referral fees to another attorney as permitted under 1.5G. 7.2, a lawyer may be recommended, employed, or may cooperate with a legal aid office, a military assistance office, a lawyer referral service, or legal service plan. There's additional detail in 7.2B that we don't discuss. Okay.
All right, I'm just going to pop in and give the first course code. The first course code is ethics. I'll give everyone a minute to write it down and I will type it in the chat. The first course code is ethics.
Thank you. All right, so back to Rule 7.2 comments. 7.2 does not prevent you from paying for advertising, as well as employees, agents, and vendors engaged to provide marketing or PR. A lawyer may pay others for generating leads. This is, again, we discussed this earlier, provide that the lead generator does not recommend the lawyers, and payment to lead generators consistent with Rule 1.5G, and the lawyer's independent professional judgment. So that's another issue that you see in some of these opinions, the lawyer's independent professional judgment. To comply with Rule 7.1, a lawyer must not pay a lead generator that states or implies that it's recommended the lawyer. The code prohibits a lawyer from making or soliciting a political contribution if the disinterested person would conclude that the contribution is being made or solicited for the purpose of obtaining or being considered for governmental legal engagement. The comments discuss the disinterested person factors further. So this is sort of New York's existing version of 7.6 that deals with a judicial appointment. Very similar, obviously, political contribution to a judge, political contribution in general, for the purpose of being considered for governmental legal engagement as compared to judicial legal engagement, I suppose. So it's very similar. Rule 7.3A1, a lawyer shall not engage in solicitation by in-person telephone contact or by real-time computer access communication unless the recipient is a close friend, relative, former client, or an existing client. So now we're shifting gears to Rule 7.3, solicitation. So the first thing we discussed was advertisements. Now we're discussing solicitations. All solicitations are a form of advertising. Okay. So this is the extension of the prohibition against in-person solicitation to telephone contact or real-time computer communication. Pop-ups that are not live response are not considered real-time communication. What about live chats, Google messages or comments on blogs, So the differentiating factor seems to be whether or not the client is initiating that. So like on a live chat, the client initiates it. So we use often Engage as a Martindale product to for our clients. And when somebody's using that, the person, the virtual pops up, said, "You have any questions?" And then the person then begins to speak or chat with them. And at some point that case is screened and then forwarded to the attorney. So Google Messages are also private. Similar to somebody, it's usually there that the person's going to initiate a question as well. Blogs, a person may initiate a question or something like that on the blog. And that just reminds us, this came up this week where somebody posted in a blog of a client's blog, something like, "Hi, Mr. So-and-so, you helped me with my, so and such matter in the past. Can you please contact me at this phone number?" So, the blogs are the way all of our blogs are set up in our office that we don't allow for automatic comments. I think this is probably standard practice. We have to approve them. So in this case, we did not approve it because the person would be speaking about their, potentially their prior case information, attorney-client privilege, et cetera. So we just then forwarded that to the attorney for them to get in contact with the person. But again, it's as long as these communications are initiated by the person involved, then they would comply with this requirement. But nevertheless, you should ask the person to call the office with any questions or to schedule a consultation, get them offline. That's usually best practice. A lawyer shall not engage in solicitation by any form of communication if it violates these rules. The recipient makes it known that they do not want to be solicited. The solicitation involves coercion, duress, or harassment. The lawyer knows the age, physical, or emotional state of the recipient makes it unlikely they'll be able to exercise reasonable judgment. The lawyer intends or expects, but does not disclose that the legal services necessary to handle the matter competently will be performed primarily by another lawyer who is not affiliated with the solicited lawyer as a partner, associate, or of counsel. All right. So if you are engaged in these type of solicitations and you don't intend to handle the matter yourself or your firm, then you need to disclose that in your solicitations. That's going to be performed by another lawyer or firm. And again, this refers to solicitations, not advertisements. So you don't have to necessarily do that with respect to an ad. Solicitations also trigger filing requirements. Solicitations are advertisements that are targeted at a specific recipient or group of recipients, family, etc. There's 4 criteria as well. It's an advertisement initiated by a lawyer. Again, all solicitations are advertisements. The purpose is persuading recipients to obtain a lawyer, motives to make money. But what differentiates it from an ad is that it's directed to a targeted or specific recipient or group of recipients or their family members or legal representatives. So usually what triggers it for me is often if I'm dealing with a fixed list. If I have a list, if I know who the people I'm trying to reach are, then it says to me this is going to be a solicitation. All right. So it's usually direct mail. But the rules also say that, and I think this gets confusing, that it can also include a website, a newspaper, and TV if it's only applying to a finite group of prospects. Now, the question that comes up is whether or not you need to know the names of the people or not. I think I'm not sure if we'll get to it, but I think the new model rules proposed by the ABA talks about that, knowing who the person is. I don't recall the language exactly, but it's just differentiating factor potentially. But in New York right now, it says it could also include web, newspapers, and TV without necessarily knowing, I believe, the way I would interpret, not necessarily knowing who the group of people are. 7.3C1, filing requirements, copy. You have to file a copy of the communication with the disciplinary committee, transcript of audio or video. If it's another language, an English transcript is required. Copies and list must be retained for 3 years. So you don't have to provide your list, but you have to retain your list for at least 3 years. But again, and what we just talked about, if you don't have a list, you don't know who the recipients are, does that make it just an ad at that point? If the solicitation is directed to a predetermined recipient, a list containing the names and addresses shall be retained for at least 3 years following the last dissemination. That's 7.3C3. 7.3C5, filing requirements do not apply to websites unless it's designed for and targeted at a prospective client affected by identifiable event. 7.3D, a written solicitation shall not require the recipient to travel to another location other than the place where the person receives mail or that requires a signature. And so you can't use certified mail or overnight services requiring a signature. The 30-day prohibition, there's a 30-day prohibition from soliciting personal injury of wrongful death claimants. 15 days where there's a filing requirement, such as like a notice of claim requirement within 30 days. It also applies to defense counsel. Does not apply to personal injury or wrongful death arising from a common cause, but at disparate times and places. So the 30-day rule is event specific. If the ad makes no express reference to a specific incident and is disseminated, it does not violate the rule unless it's directed to a specific recipient with the knowledge that they are a victim, even as part of a mass mailing. So you can't do a mass mailing and knowingly include victims within 30 days or 15 days if that's the requirement. So in other words, and this kind of says to me, you can't use like, for instance, if I knew the address of a personal injury victim, I can't and I knew who the victim was, I know where they live, I'm trying to reach their family or them, and this comes up like public records. I know a lot of number of attorneys are using public records in certain states and maybe everywhere to reach personal injury victims. That you can't do a mail-in to a larger geographic area. And this kind of brings up one of the techniques I think we'll talk about is the post office EDDM, every door direct mail. EDDM allows you to saturate an area, a geographic area that a postal employee, it's a carrier route. It's the postal carrier's route. Usually they're around 500 houses. You can't say, all right, let me drop an EDDM mailing, general EDDM mail, and it could just it could even have no reference to the incident, but just talk about, let's say, personal injury services, or maybe it's even talking about a specific sub practice area that affects this victim. You can't do that as part of a mass mail and do 500 pieces of mail, let's say, to reach that one person that you want to reach. So in these circumstances, the in-person solicitation rules apply as well. This is what the comment says. Even that the recipient is a close friend, relative, or former client. That's comment 9. Solicitations to a predetermined recipient, the 7.3F, if prompted by a specific occurrence involving or affecting the recipient, shall disclose how the lawyer obtained the identity of the recipient and learned of the recipient's potential needs. So again, if you're using public records to reach people, you're going to have to mention that in your solicitation. But the rule is also not specific to personal injury cases. So you could also, this may also come up in a bankruptcy filing or the filing of lis pendens. You'd have to note that, we obtain your information by purchasing a record of people that, our lis pendens has been filed against. So you have to mention that in your solicitation. If a sample retainer's agreement is included, then the top of each page shall be labeled sample in red ink and in a size equal to the largest type size, and the words "do not sign" shall appear in the signature line. So I don't think I've not been involved, and I haven't heard too many lawyers include in a sample retainer agreement, probably because of this reason. And I guess you could say that because of this, this is an area, and I'm thinking in terms of like services that are provided by non-legal professional firms, and I'm thinking some one area could be like tax grievances, for instance. I know some lawyers do that, and then other non-lawyers also will file tax grievances on behalf of people. And I've seen an agreement in there, like a sample retainer agreement. Uh, that people could sign up and send that back in to the to the organization. So that's a little bit of a disadvantage there because of this rule to attorneys who do the same work, possibly. 7.3H, any solicitation shall include the name, principal address, and telephone number of any lawyer or firm whose services are being offered. 7.13, provisions of the rules shall apply to lawyers not admitted to practice in New York State and who solicit retention by the residents in the state. So the out-of-state attorneys must also comply with this rule. But again, we're making a differentiation between advertisements and solicitations. 7.4, the identification of practice and specialty. So again, the new model rules that New York has not adopted eliminate 7.4 and 7.5. And I think one of the reasons why is just the practice of law firms and how they're more and more identifying in a certain practice area the way attorneys practice law is probably overpassed or surpassed the rules in some cases, and we'll take a look at that in a second. 7.4A, a lawyer may publicly identify one or more practice areas, provided that the firm shall not state that the law firm is a specialist or specializes in a particular field. 7.4B, those admitted to practice for a U.S. Patent and Trademark Office may use the designation patent attorney or substantially similar designation. But again, I think this is an area where attorneys now refer to themselves as an elder law attorney or as a personal injury attorney as well. So I think this rule is getting surpassed by attorney practice in many ways. A lawyer may state that they have been recognized or certified as a specialist only as follows: by an organization approved by the ABA, along with disclaimer provided in 7.4C, certification in another state provided inclusion of disclaimer in 7.4C2. Now 7.5 outlines the use of websites, business cards, announcements cards, office signs, and letterhead. A lawyer shall not practice under a false, deceptive, or misleading trade name, domain name, or name that is misleading as to the identity of the lawyer. Okay. So legal aid, legal service office, legal assistance office may only use by bona fide legal assistance organizations. You may not use the term not for profit unless the firm qualifies. The law firm may not include the name of a non-lawyer in the firm name. It shall contain PC, LLC, LLP. So if that's often something that comes up with regards to logos and how firms are presenting themselves. So if you don't have it in your logo, then I would certainly have it someplace else on the communication, such as letterhead or website, to say what the what it is in terms of legal entity. You may use a phone number that contains a trade name, domain name, nickname, or motto that doesn't otherwise violate the rules. A law firm that has contractual relations with a non-legal service firm may not include in its firm name the name of the non-legal service firm. Okay. You may not use the name of a judicial, legislative, or executive office holder while during the period where the lawyer is not actively and regularly practicing. Okay, so and you certainly wouldn't be able to add a name that of somebody who, let's say, has a limited involvement in your firm and is not practicing. not false. It's not false. This is 7.5 comments. It's not false, deceptive, or misleading for a firm to be designated by the names of all or some of its members or by retired or deceased members where there's been a continual line of succession of the firm's identity. So you see that often, obviously, some very old firms, they continue to go by the name of, founding partners, let's say, or early partners. You may not use a name that implies a connection with a government agency or state as nonprofit unless it qualifies. May not use a name that includes the words legal services, legal assistance, or legal aid unless a firm is a bona fide legal assistance organization. Communication signs, et cetera, may include the non-legal business conducted by a lawyer. That's important to know. I think more and more lawyers are providing non-legal services as well. A lawyer may be designated as counsel, special counsel, or of counsel on letterhead, et cetera, if there is a continuing relationship with another lawyer or firm. A lawyer may also be designated as general counsel on the stationery of a client, such as a corporation. You can be listed as general counsel on there. All right, 7.5B, trade name comments. It's proper to practice under the lawyers. This is in the comments of 7.5B. It's proper to practice under the lawyer's or law firm's own name, initials, trade name, domain name, abbreviations, areas of practice, and variations or combinations, etc. So these are some examples that are given right in the comments. So I think this obviously opens up quite a lot regards to how lawyers present themselves and their so-called specialties. If Abel and Baker are attorneys' last names, these following trade names are permissible. Abel, Baker, real estate lawyers. So again, that's saying that specifies their area of practice that they seem to specialize in. A and B, real estate lawyers, just the initial that's in there. Strictly a trade name, dirt lawyers. Domain names such as realestateLaw.com or ablerealestatelaw.com. Firms have been doing that since the beginning of the internet. And also something like Albany Personal Injury Lawyers is another trade name as well. All permissible. 7.5B, trade names or domain names may not be false, deceptive, or misleading. You cannot use a trade name or domain name such as winyourcase.com. Telephone numbers such as similar to trade names may use a combination of, so I think the problem with this is, it's implying results or guaranteeing results here on that trade name. So it cannot be false, deceptive, or misleading. And if you're going to have a domain name like this or a domain name, you have to be able to back up your results. Similar to trade names, you may use a combination of a firm name and numbers, such as, again, this has been done by lawyers since they first started advertising. 1-800-ACCIDENT, 1-800-HURT-BAD, 1-800-INJURY LAW. But you may not use phone numbers such as 1-800-WINNERS or 1-800-TO-WIN-BIG or 1-800-GET-CASH. So I obviously think that, in between these two areas, this could be a little bit confusing here, but in between these two, there's probably plenty of gray area as well. 7.5C, lawyers may not hold themselves out as having a partnership with one or more lawyers unless they are in fact partners. So this comes up from time to time, like in a joint venture. So you can't have a trade name that covers, that makes it seem like there's a partnership between two firms when there isn't one. So a partnership shall not be formed or continued among members licensed in different jurisdictions unless all enumerations of the members and associates of the firm on its letterhead make it clear the jurisdictional limitations on those members and associates. You may use the partnership name maybe used in each jurisdiction. So this first provision here, that's why, you would often see on letterhead of a firm that practice in more than one state, you would often see, the different symbols indicating that, that this attorney, practices in New York and New Jersey, is noted by like an asterisk. And then if this attorney practices in New Jersey and Connecticut is, noted by a cross. So that's where you would see that quite a bit at one point. I think as practice these days, law firms are probably printing less letterhead. I think now as a general practice, you see law firms having the general stationery, and then every attorney has their own, letterhead is one way to get around that. Political contributions this is Rule 7.6. This is Model Rule 7.6, not in New York, though we would mention it. Political contributions to obtain legal engagements appointment by judges. Some states have adopted Rule 7.6 that prohibits a lawyer from accepting an engagement or appointment from a judge if the lawyer makes a political contribution for that purpose. Right. So I believe we included in our materials a chart that talks about which states have adopted which rules or deleted 7.4 and 7.5. 5.7, though we should mention 5.7 and 5.8 as well. 5.7, this applies to services that are not distinct from legal services. Where legal and non-legal services are not distinct, the lawyer providing non-legal services is required to adhere to all the requirements of the rules with respect to the non-legal services. So the rules would apply. All ethics rules, et cetera, would apply to these types of service when there is not a distinction. Unless the client understands that the non-legal services are not subject to the attorney-client relationship, and they advise of that in writing. So again, important to include in your retainer agreements. There's also obviously conflict of interest considerations, making basically referring the client to the non-legal service that the firm's providing, within the firm. 5.8, 5.8, again, the difference is 5.8 is these non-legal services, professional services being provided by outside the firm. You cannot share legal fees with non-legal professionals. You must disclose the contractual relationship before referring somebody to a non-legal professional service firm. You must provide a statement of client's rights and cooperative business arrangements. Lawyers may enter into interprofessional contract relationships provided the non-legal professional service firm does not own, control, supervise, or manage the lawyer's or law firm's practice. And there's some opinions on that as well. 5.8. Comments: a law firm may not include in its firm name the name of the non-legal professional service firm. The contractual relationship may provide for reciprocal referral of clients by and between the lawyer or law firm and the non-legal professional service firm. The referrals should be made only when requested by the client or deemed reasonably necessary to serve the client. And referrals may not be made on an exclusive basis. Okay, again, a few states, just checking on the time, a few states have adopted the new rules since 2018. We touched on this. Okay. Went through this a little quickly. Some of the key differences between the existing rules and, let's say, Virginia. 7.4 comment 4 talks about area of expertise or specialization. A lawyer who is a specialist in a particular field of law by experience, specialized training, education, or certified may communicate that such specialty. So again, just want to caution you that, this does not apply in New York, but if you're in one of these other states, including Virginia and Connecticut, this, again, check the specific state rule. We are giving a lecture, by the way, to the Connecticut Bar Association in a few weeks, but check your state rules. I just want to mention that these are some of the changes in the model rules that I found proposed model rules that some states have adopted I found interesting. All right, so you may communicate to specialty. Rule 7.1, comment 5, you may use legal clinic. So for example, Springfield Legal Clinic may need a disclaimer that says it's not a public legal aid agency. You may use it, but you would need a disclaimer saying it's not a public legal aid agency. 7.3, solicitation of clients, this I thought was helpful. Specifically says directed to a specific person known to be in need of legal services. All right. So you would have to, know in the case of a solicitation as compared to an advertisement, you would have to know the specific person in need of legal services. So if you just know of a certain pool of personal injury victims, I think this helps clarify things in this 2018 model rule change. Some other key differences, written materials shall include the words advertising material on the outside of the envelope or beginning of a recording or electronic solicitation. So this is interesting because, I mentioned, or it must have been around 2007, 2008, there were some proposed new rules in New York that we were complying with for clients. And, we had done a solicitation letter on behalf of a New York City law firm it might have been commercial property tax grievances. I can't recall exactly what it was, but on that letter to individuals, businesses, I guess, on the outside of the envelope, I had put on there attorney advertising on the outside of the envelope, but not inside the envelope. So at the time, there was in the earlier rules, 2007, 2008, and maybe this was 2009 or 2010, after New York had adopted its rules, that those more strict rules said at that time, the proposed rules that were not adopted said put the advertising label on the outside of the envelope. And it makes sense because, if you're not an attorney, and you don't communicate often with law firms, you get a lawyer from a letter, what's the first thing you think? Well, what's this? So could this be about? It's usually, no offense to all the lawyers in the audience, myself included, no one wants to hear from a lawyer really. So it's important to, so I believe the rule in this rule, let the person know if they're getting a communication from a lawyer, an envelope, that this is advertising. So they're not concerned about opening it and so forth. So what happened was that the local disciplinary committee contacted my client and said, you violated the rule. You didn't have attorney advertising on the inside of on the letter that you guys sent out. And we had a conference call and explained to the person, I feel like we overcomply. We put the advertising label on the envelope. That's more important. And I explained this to them. But didn't work really. All they really wanted you to say, we promised not to do it again. So my argument really didn't go anywhere. But, so I am, somewhat happy to see this revision and, that the attorney advertising, or in this case in Virginia, advertising material is on the outside of the envelope. Rule 7.3, comment 4, paying others to recommend a lawyer to comply with 7.1. A lawyer must not, and again, this is a relatively new rule, 2018, these new rules were proposed. As I mentioned to you, a lot of the ethics opinions from the last several years have been dealing with lead generation sites. So to comply with Rule 7.1, a lawyer may not pay a lead generator. It states, implies, or creates a reasonable impression that is recommending the lawyer is making the referral without payment from a lawyer, or is analyze a person's legal problems when determining which lawyer shall receive the referral. So, I think I'm not sure if we'll get to it, but basically these lead generation sites, they have to be almost mechanical in how they in how they send a referral, not referral, but send a lead to an attorney, based on things such as like geography or practice area. and cannot imply that they're making the recommendation that you're getting the best attorney for their case. All right, so we're going to skip over Alexander versus Cahill. It's in here, somewhat historical at this point. We touched on it during the earlier part of the presentation, but it's here for you to take a look at. All right, so we're ready for the second portion of our lecture. I think we have about, if I'm not mistaken, I think we have about 55 minutes remaining. Brad, are you?
I'm here.
All right, very good. All right, Brad. So we just first part we want to talk about was strategic planning and research.
Yeah. So basically, if you're part of marketing of any big organization, I use Morgan & Morgan. That's a big law firm, for example. You don't just go, I'm going to just decide to do this. You have to have a budget. You have to know what you can do and how much money you have to work with so you can plan your marketing campaign correctly. And a lot of lawyers don't do that. And a lot of small businesses don't do that. They just get an idea and run with it. And that's not usually the best way to go. So you want to take a look at your clients, your existing clients, and maybe you want to target a different type of client. So you want to look at, what do you have now as clients? Are you strictly a local law firm? Like, are you in Long Beach and only want Long Beach clients? Or, do you want all of Long Island, for example? So you really want to know that. You want to look at where are your clients coming in? How are your practice areas? Are you focused on one practice area or you do multiple ones? And then you want to also look at your demographics, like your age, gender. You can do household income, all that kind of stuff. So most lawyers and most businesses, actually small businesses, they don't track their ads. They don't know where their ads are coming. I mean, the clients are coming from. They just throw something out there. They have one phone number and they just ask everybody who's calling, how'd you hear about us? And that's usually not a very effective way to go. So if you don't have good data, you're not necessarily going to make the best decisions. So that's something you want to take a look at. Now, your target client, who do you want as your target client? Are they completely different than what you have now? If so, you need to have a plan of attack to get them, right? And then you're going to decide how much money you're going to spend to get to these people. And if you have profitable client segments, then, do you want more of them or are you just sick of that kind of law? So most people don't like to give up profitable client segments. Now, I'd love to say every law firm or business has 5-year goals. I was in charge of strategic communications division for the National Guard Bureau in DC. We had 5-year plans, but you know what? We called it strategic reactionism because whatever was happening right then and there governed over any 5-year plan. So realistically, look at a year to 6 months. Just that, if you can work with that. Attorney referrals. Do you get attorney referrals from various things like CLE events, maybe like what we're doing now, bar association events and those kind of things? Do you actually reach out to these various centers of influence to get business and to get relationships? Do you use LinkedIn? Do you engage in LinkedIn forums, those kind of things? Do you send e-newsletters to legal peers?
Yeah, like for instance, Brad, like the forums, it could be, I see people on iLaw, the bar associations, the state bar associations have, their committees have forums, and they're often asking, attorneys on there legal questions, or if they could refer somebody that they've worked with in the past. So I think those are good ways to get business, as well as, and we mentioned earlier, the attorney referral services, if that the bar associations maintain source for business.
Yeah. So now we talked about professional referrals, like going networking, all that kind of things. Are you involved in a network group? Some of them are effective, some of them aren't, depending on the type of law you do. And do you get involved in charities, for example, and professional associations? I know a board I'm on a charity board I'm on. I think 3 out of 6 or so are lawyers, and one's running for judge, so she just got off she's not on it at the moment.
Yeah. The one thing I would add to the networking part of this is for professional referrals is try to, sometimes it's better to be in, and there are exceptions, but try to be involved in a group where everyone who goes to that group can be, is an ideal client for you. So like for instance, if you do a lot of work with restaurants and you get involved with restaurant associations, et cetera, so that rather than more general like regional chambers of commerce, local chambers of commerce, if you're a personal injury attorney, that may not be the best use of your time. Try to be in front of groups that are best for you, that everyone there or just about everyone there could be a potential client.
Yeah. So your reach, I mean, how big do you want your geographic reach to be? If you want it to be really large, you're going to have a large budget. You want to do a smaller area, then you don't necessarily need as big of a budget. That's not always the case, but you generally don't. And local newspapers are still a good way to get business, primarily because if you're in the elder law market, for example, I'm down here in Florida. They love printed stuff. They love direct mail. They love newspapers. They also love free lunches or dinners. It's got to be an early dinner. But they'll show up. They do. And they will have the printed thing in their hands. So don't rule that out. And we'll talk a little bit further about these things in the
Yeah, we've
lecture.
done those in the past for elder law estate plan attorneys. They were working for a while, inviting people to, meetings at your office, lunches, breakfasts, et cetera. But Brad, you also mentioned like, the TV and radio for wider geographic reach, but, again, the Google ads is for wide geographic reach, but also for local reach too.
Yeah, that's a good point.
You could target those, right?
Yep.
Uh,
You can target down to a neighborhood if you felt like it.
Yeah, certainly. Yeah, zip code or in a lot of the digital advertising, you can upload a list.
Yeah.
As well.
Yeah. So demographic specific, you can tailor it to the group you want to do. Like I mentioned, seniors, business execs. Maybe you want to target veterans. Maybe you're, a disability veterans claims lawyer, et cetera. You can target veterans, and veterans talk to each other. So you do a good job for one, and you do a good job for a lot more.
Yeah, and in some cases you could purchase lists for some of these as well.
Yeah.
Board of Elections data for seniors, businesses, database service, disabled. There's lists out there for a lot of these different things.
So earned media is what we call, you earn it. You don't pay for it. You earn it by doing the right things and contributing to the right avenues to get people to be aware of who you are. So you want to leverage what's going on locally in the legal arena or the policy arena. For example, if there's a new bankruptcy provision or something that's going on and people are wondering if bankruptcy's up, well, then you're a bankruptcy attorney, enter the conversation just as though you're in a room with people, highlight what you know and how you can help people by adding the knowledge to that conversation. You can showcase positive case results. If you have a big case, big case results, and maybe you can't necessarily disclose everything, but if you can, tell people about it. People like billboards all over the place.
Brad, you're breaking up a little bit. So something you could do and these things is not only include on your website, but also send out a press release talking about your positive case results. And I think we'll talk about some of the other techniques soon. Brad, has Starlink doing better there?
Yeah, I think. Yeah, we must have a flyby over there. So, I used to be in the space arena, Air Force Space Command, et cetera. So there's a lot of stuff up there. Maybe something flew by. One time we had a rocket launch and everybody else talked about it, but we were forbidden to talk about it. Everybody saw the rocket take off. We couldn't say anything. So let's get back to this. So new partnerships. If you've all of a sudden partnered with, you got a new partner or something, tell people about it. It's a change. And if somebody came in that's notable, somebody like, I got to write something for the business column or something like that, they can put it in there. At least it shows people you're growing and you're not shrinking. Community involvement, charity involvement, highlight it. This is not the time to necessarily just do it for the good sake of doing good. I mean, that's good, but you really want to tell people about it. Promote educational contributions and speaking events. If you're speaking at a local, I don't know, Rotary or something like that, talk about it. You might get some play on it, and you might get a media person go because they want a free lunch. So there's a variety of ways you could do these things. Now, if writing content is not necessarily something everybody has the time to do anymore, right? If you're busy working, you don't really necessarily go, all right, I got to write this piece, but you can work on it, and you can use the tools that are available now to hopefully help you get something done, at least a draft, and then you can polish it later. Podcasts and radio appearances are good. They're not widely listened to necessarily if an attorney's talking, but if you're a business to business attorney, you're an attorney trying to get corporate outside counsel stuff, corporate law clients, et cetera, it might be a good thing for you to do.
Yeah. And, while we're creating this earned media, and PR is often part of our content creation strategy, so if you're getting, not only you're doing the press release, or, you're taking that press release, you're communicating your e-newsletter, you're doing social media posts based on it, you're writing, the authored content, so if you're going to write the article, great if you get it published, but even if you don't, you post it on your blog, you send it out as part of your e-newsletter, you send it out to as in your as an alert, let's say, to your client base and other people you're in contact with. You're taking this. Some of this content takes a while to create. You might as well make as much use of it as possible, repurpose it where you can, and then if you do actually get the hits in the media, then obviously now you could show people that you're in the media. I think it's one of the best things about press. Although sometimes if you get a big press appearance, it's very short term, the impact on your business. But I think what you see is that you put it on your website and it helps to build your reputation that, hey, this is somebody who person the media goes to, or is in the media. So they, potential clients say to themselves, they must know what they're talking about, whether that's true or not. But
yeah. So press conferences, you don't see them a lot, especially with attorneys. But if you've got something major, like you just won an appeal against Trump, for example, whatever, remember we had that client, John, a few years ago, the appellate lawyer. He retired, didn't he?
Yes.
But he highlighted that, he didn't do a press conference on that, but he highlighted he beat Trump's organization or something. I just remember that.
And it depends on the practice area. I think it might be harder for other areas of law, but as Brad and I both have a PR background, what you don't want to do is you never want to hold a press conference and then nobody shows up, right? So you have to pick and choose. So that's where, and I think it's on the next slide, you have to choose between holding a press conference or just send out a press release. Anytime you do a press conference, you're going to send out a media advisory. You're also going to do a press release as well. But we also have worked with a civil rights attorney for years, and that type of when he announces cases, usually it's against some type of public entity, whether it be governmental, police, etc. That gets a lot of press coverage. So it's also known like what your how much interest the media is going to have in your press conference or even press release.
Was that Fred was his name, right? Fred.
Yes.
Yeah. Okay.
Right. Go ahead, Brad.
All right. So we'll move on from the press conferences. Yeah, but it's tough because you might have a press conference and everybody wants to attend, and next thing you know, there's something happened bigger, and they just go, I'm blowing that off, and then you're there with the client, duh. So
if you're going to do them law office or some type of public place that resonates with where you're getting out there, and the media is going to ask you, they're going to ask, like if there's a plaintiff or victim available, and that's a call you're going to have to make if that's something you're going to want them to talk to the media, when you announce in a lawsuit or when you potentially resolve the lawsuit. Very often attorneys are hesitant to do that. But sometimes it might be necessary, and that's what the press is going to look for.
Yeah.
Brad.
Yeah. So media advisories, anytime you're doing something, you got to advise the media that this is happening, so, hey, I'm here and I understand this, this sexual harassment suit just happened, and I'm here to talk about it or whatever. So call us and we'll talk more. I'll appear on TV. And if you do appear on TV, You should have a little bit of, media training before you get right there on there. And one way to practice, if you're ever doing a remote, is to do a Zoom when there's nobody, you're looking at nobody. And that's pretty much so you can just get used to talk to a camera with no feedback from people. So,
So the one thing
uh,
about with media availabilities is that, a lot of times, I think we'll talk about this a little bit more. It's very often, so it's not your case. It's not, but it might be an area that you practice in. Sending a message out there saying that I'm available to talk about this, and this is what I would say. Very often that it's the early bird gets the worm on that. So check the New York Times, listen to the early morning news, and see how that might work in well for the more local or regional news people. Sometimes you get a hit on this stuff.
yeah. I mean, we're doing that. I do with a client where their local paper, I read it every day, the online version, and see, is there a way to, comment on something that's just been reported? So you can do it. Uh, we talked about leveraging you as a go-to experts, right? And here's some experts, examples of expertise highlights, a spotlight, medical malpractice. All right, there's a change. I'm going to talk about it. Elder law. All of a sudden, nursing homes have issues. There's bed bugs in a nursing home. I'm going to talk about are the legal ramifications of the law if they change, the reporting of bed bugs or something like that. Real estate, that's all over the map now. I mean, people are constantly wondering, what's going on with the real estate, especially commercial real estate. So enter the conversation, talk about that, and you can talk about, is the real estate commercial market causing bankruptcy, corporate bankruptcy filings to happen with those people who own commercial real estate. So you can just find different things that are going on. Inflation, boom. We got a hurricane, what's that going to do? The port closings, what does that do? I mean, there's a million topics you could talk about. And immigration law, immigration's of an interest topic around. So you can
That
talk
often
about
comes from
that.
clients. Yeah, and the
Yeah.
one thing, like I got a kick out of this. I was reading in the I think it was a Newsday article on Long Island about a month ago or so about some of the recent real estate. I'm not sure, it was probably recent. There was a few changes, but it might have been the new disclosure laws. Might not, I may be mistaken on what it was, but the reporter had two sources in the paper, two lawyers, real estate lawyers. One person they interviewed because they had recently held a continuing legal education lecture before one of the local bar associations. And the other person they quoted because they did a blog article on the topic. So they obviously went online, found who was speaking about the topic, and then wound up using them in the article. So
Yeah.
there's lots
And
of things
yeah.
out
And the more you do that, the more, especially with TV, the better guest you are on TV, the more likely you're going to be invited back. Because then the reporter or the news director is not going to hear it because they invited this person who couldn't speak on TV,
there.
So
In news media, like, things happen quickly. Like, so it's the morning, they're figuring out what they're doing stories on, and then they start scrambling to see who they're going to get to talk to or who they're going to interview or what's on the agenda for the day. So, so ideally you want to be that early bird, get the availability to them. But over time, ideally what you want to see happen is this, you want to position yourself as the go-to expert so that you don't even have to send them out an advisory. They're just going to call you. You're in their Rolodex, or I haven't been in a, I'm not sure exactly what they're using now, but
yeah. Let me
yes,
whip out the Rolodex here.
you want to be top of mind
Yeah.
as you're the person to go to. But all right, so you want to become that trusted legal source over time.
Yeah. So
Talk about
let's look at something article writing, right? I mean, let's face it, lawyers, you did a lot of writing, you do a lot of writing, so strategically write articles, let's say I'm going to write one bar article a year or something like that, or one trade article. Maybe there's a weekly column that's now probably online where you talk about one legal issue affecting, pick your topic, and talk about it. It doesn't have to be big, you just want to be out there.
Yeah, and
and
a
do
lot of times the bar publications they're pretty open to columns and submissions and it's nice there to get into a regular column with them or with a business publication, let's say, or a local newspaper. So that could be used quite often in your marketing efforts as we talk about here.
yeah. And whatever you do, you want to integrate it to your website, right? So everybody can see you're building your website and putting new content on, and you're going to use it for your blog, whatever. You can change the article if it's to fit a blog type of format or break it into multiple blogs. So whatever you do, and this is a common theme with us, whatever we do, try to get multiple uses out of one energy expenditure, so to speak.
Yeah, and a
Don't
lot of times it's often better to write, for the public and not necessarily for other lawyers.
right.
So we'll often, be able to do that in like even a bar publication, versus and a business publication.
Yeah. So you want to hopefully you're doing a digital e-newsletter every month or 1 month to 2 months, and you're doing a printed newsletter maybe once or twice a year or once a quarter because people digest information differently. And sometimes you're looking at the computer all day, you don't feel like looking at something, but you got a
Yeah.
printed newsletter, you read it.
Yeah, we'll probably talk about this a little bit more, but we like to stay in front of we recommend to attorneys stay in front of your past clients, whether that be with start them out with a brochure and then 6 months later maybe send them something like a printed newsletter, and then hit them up with e-newsletters in between, just to stay in front of them, especially if you have multiple practice areas, because we often hear hear regrets from attorneys saying, "Listen, I handled one type of matter for a client, then I heard that they went to somebody else for this other thing that this other practice area that I actually do." So you want to make sure that they know and don't assume that they know you'll handle these other areas of the law or your firm does.
Right.
So, the last line,
Yeah.
also then mail the articles to potential clients for more direct impact. There's a local attorney who writes a bar publication. He does a great job of as that publication's hidden, he sends out a PDF of that article to his contact list. So he gets probably as much, if not more, impact from the email blast as he does from the actual article being published in the bar publication, especially to non-lawyers.
Right. So you want to have strategic, if you're doing business to business, you can use a lot of public records or even business to consumer, to get information that's good for you to do. I mean, traffic tickets obviously they're out there, divorces. I won't repeat my divorce story that involves that, but you can learn a lot from public records and market if you want to do that. So, and you can also target mailings based on specific geographic or demographic information or both, So if, for example, we had a Hurricane Ian 2 years ago, really did a lot of damage and people are still fighting their claims. You could do a mailing, right? And you could say, I want mail this neighborhood. These people have these home values and you might get something.
Mhm. Yep. Yeah, and you could obviously the targeted mailings, you could buy lists, you could base it on geographic, demographic data, et cetera. So you could and in many cases, yes, public records as well.
Yeah. So we talked a little bit about this before. You can target seniors if that's your group. You can target them. You can target the real estate, broker list, obviously. If you're doing closings, for example, build relationships with realtors, and you should be doing it anyway. Elder law, direct mail, like we talked about, they trust something that's printed, and they don't necessarily trust Facebook stuff. So you may get a lot of leads via Facebook, but then you'll call them and they won't even know who you are, typically. All right, so network expansion. You want referrals and you want to give referrals. So compile your list and network with your list. That's what you should always do. A personal touch, we like this, holiday cards, not emails, holiday card if you want to do that, birthday cards. Everybody's sending out the email, happy blah blah day, you know. and you get them in the email, but if you print something, they know it took you a little bit more effort to do.
Yep. Yeah. Again, try to stay in front of them at least once, maybe, twice a year, something printed. And it's also very important, and not enough attorneys do this, is to maintain, good, computer records of your past clients, whether you're using your practice management software, or if you're using, Microsoft Outlook, or if you're using even an Excel file, try to maintain some type of record of your past clients and prospects and stay in touch with them.
Yeah.
They are the lowest hanging fruit, is your past clients in terms of
Yes.
advertising.
Yeah. Penny savers, John, I've forgotten about penny savers, but I know they're still there in Long Island. They're a cheap way to get front page exposure for your law firm.
Yeah.
And don't forget direct mail, D cards, which are detachable cards that are, in circulars, for example. And then every door direct mail is a real cost-effective way to get everybody in an area.
Yeah, so if
So
you're trying to like saturate an area, a local attorney, the penny savers are good because they go to every household. I think it was Newsday just announced that they're stopping their hometown shopper. But you still have some of these local penny savers around where they go to every household, they get mailed. And because they get mailed to every household, they're allowed to do these D cards. And I just happen to have, I'm going to try to I happen to have this on my desk. This is from Penny Saver. Was These are the D cards. So it's two-sided, as you can see. There's a mail-in area, and there's another. So this is about a 6x4 card, 6x5, and they're nice. They feel good. It's good quality. So because the Penny Saver goes to every household, they can get these detached cards at a low rate. And if I'm not mistaken, you could get away with, usually these penny savers go to about 10,000 houses, but you could get these for about 12 to 15 cents. So only about $1,500, a high quality card to reach everybody. And then you could also, so that's one way of doing it. The EDDM, I already mentioned, the postage on that's going to run about 20, 21 cents to hit every household. And then the direct mail, let's say if you're doing bulk mail, you might probably be in a 30 to 35 cent range for postage. So just something to consider, in terms of how you're reaching people or saturate an area. But the D card and EDM will allow you to saturate every household. The direct mail piece, you could use that for your, like Brad was talking about with your list. You're going to pay more for postage there. Okay, Brad, are you still there?
I'm just going to pop in and give the second course code. The second course code is marketing. I will give you a minute to write it down, and I will also type it in the chat. The second code is marketing. Thank you.
Okay. All right. I'm not sure if we lost Brad with his Starlink, so I'm gonna text him and then I'll just continue here.
Yeah, it appears he popped off completely. It's not that he had bad service. He should be able to re-click on the link and hop back in.
Okay. All right, well, very good. I'm going to continue with it, and I'm not sure if you'd have to let him in or not, but he actually just clicked right through. Okay, so if we have to communicate that to him.
Yeah.
Well, there he is.
Pop right back in. Yep.
We delayed long enough for you there, Brad. You got back in.
All right, there you.
You didn't miss much.
Okay.
I was still talking about D cards and EDDM. So.
Oh, perfect.
All right.
I figured you'd drone on about that. So no.
Yeah, it is kind of one of my favorite topics. So what am I supposed to do? Anyway, so just continue with the screen here. TV advertising.
I guess somebody wants to know what the first code was. Ethics. All right. TV advertising. Now you can advertise on a lot of different things now, but typically we find that sports and news within a specific area are actually probably the ones where you're going to get people of all kinds of, doesn't matter what their economics are, et cetera, So, for example, if you're a Mets fan, it doesn't really matter, right?
Yeah, and that's
so
when we're doing advertising, TV advertising lately, this is what we're sticking with. It's it's news and sports that people are tuning into. It has a guaranteed audience, and they're still using traditional, cable TV or broadcast for it. Whereas, a lot of the other programming, they may begin from streaming services, et cetera. So these are the two areas that have, still have high ratings, and that's usually where we gear our advertising dollars if we're doing TV.
Yeah. Yes, in the Q&A box. Okay, all right. Radio advertising, we talked about the same kind of thing, sports and news. Like I tune into 1010 Wins every other day, and then I listen to WTOP, which is a Washington, D.C. station. And I get marketed to on 1010 Wins from Florida attorneys. So go figure that. But but news and sports you want to do. And yesterday I happened to through the Starlink, whatever, I got New York news, and it was like Long Island news. So I learned about everybody running for Congress there in Long Island. So you can do it with radio too. I mean, people are listening to the radio. Having been through a few hurricanes before, you don't watch a lot of TV. You got your radio, and so it's something to do, and it's cheaper, obviously, than TV.
Yeah, and they're reaching you, Brad. You're on their digital platform, so they're reaching you with those ads to their digital platform, whatever way they might be
Yeah.
targeting you. But we also, one other thing with regards to radio, we do prefer, live reads if possible, to traditional commercial spots, because we also prefer, AM radio over, let's say, FM, because a lot of times on the FM dial, you're in these long blocks of uh, of commercials, and often will hear them talk about, hey, we only play commercials once an hour.
Yeah.
That's not good for an advertiser. You want to be, because when that comes along and you got this 5 minute block of commercials, well, guess where your viewers are going? They're going someplace else. They're going to another channel, or they're going off into digital. But they don't do that when it's as much when it's a sporting game, because they don't want to miss the beginning of the game when it comes back on. And they won't do that on news, and news tends to be on AM. So we tend to prefer AM radio for law firms. And we also prefer the live reads where you'll have to pay more money, probably about twice or so, if the live, the on-air personality is reading your commercial. We did something recently where we paid a little bit of a premium to be the first commercial in the commercial block, with a news-oriented spot. So that's another technique that you could utilize.
Outdoor advertising, you don't have a lot of billboards in New York. The rest of the country does. Evaluate the cost. It's usually very expensive, and you'll find that they'll tell you, well, 30,000 people pass it every day. Well, 30,000 people may pass it, but about 1,000 people maybe looks at it. And I used to ask people when I met with them in person to say, what'd you think about that billboard? Right outside. Huh? They just don't pay attention to them. But if you want to get some bang for your buck, Adopt a Highway there in New York, for example, is relatively cheap, and you're doing something good for the community. So it's a win-win.
Yeah, those begin at a few $100s, maybe $300 is probably one of the lowest ones. As you get closer to the New York City, you can probably I think I've seen closer to like 1,500, somewhere in between. But as Brad mentioned, we don't have as many billboards, or the ones that we do are very expensive. As you get closer to Manhattan, probably our most common type of billboard is the train trestle ads. And even those are a few $1,000s, maybe up to $5,000 a month for most of those, if they're not more.
Sponsorships, these are not necessarily a bad thing. I mean, if you're like, there's Americade up in Lake George, New York, or a motorcycle type of thing. And if you're after motorcycle clients, you're a personal injury attorney, it's not a bad idea to be a sponsor, of the event.
Okay. I was just checking the chat. Um,
On New York's highway, on the highway in New York City, 10,000 to 15,000 for Adopt a Highway, somebody wrote.
okay.
So,
Okay. Interesting. I could see that. We saw one that was available. Maybe it was about 6 months ago. A small adopt the highway sign, I think it was like on the FDR or something like that, was about, I think it was 15 or 1800. But the billboard signs are in the tens of thousands last time I checked, leading into Manhattan. But thank you.
And don't forget trade shows if you're there. But we can go on.
Okay.
All right.
Features. I couldn't find the back. Oh, there's the back button. Go ahead, Brad.
So digital advertising, most people Google search ads, Google ads, that's the big monster in the room. And you really can't, somebody's asking, what are your consultation rates for an advertising consult? Well, if you email us after or give us a call, then we can go over that.
Yeah, the phone number's on the bottom.
Yeah, the phone number's on the bottom. We'll tell you at the end too. So the beautiful thing about Google Ads, and you can, depending on what you're doing, you can actually really micro target, and go age, gender, location, time, household income in many cases. Yeah, you can even do just factors like people who Google thinks are in the market for an estate attorney or something like that. But typically you go, all right, I want 15, not 15, forget the kids, 50 to 60-year-old women who live and have household incomes of this in this area, for example. You can do that. And it's very useful. And as you get enough data, keep on doing it. As you keep on doing it, you get more and more data, you can better target and go, this is a waste. This segment is a waste. They're not buying. This segment is good, and you can spend more of your dollars there. So your keyword strategy is, and Google's very good at spending your money. If you don't know what you're doing, you can blow a lot of money with Google very fast. And they even have consultants that'll help you do it even faster. But what you want to do is have long tail keywords. The longer, the better, right? I want bald-headed men who wear glasses, who need an attorney for a divorce. That's a real long tail keyword. And the number of people is small, but you want enough play that you're going to get some kind of response, but you don't want too much like attorney. That's gonna send you to the poorhouse really quickly.
The other thing to mention on the keywords, Google usually gives you three different, and Google Ads is Brad's area of specialty. As you probably notice, I'm more on the traditional side. Brad's more on the digital advertising side. So I do more things such as TV, radio, direct mail, et cetera, for our clients. Brad, takes a lead on digital advertising, Google AdWords in particular. But there's three different ways you could have once you have your keywords, then there's three different types of format. One is what, Brad, the broad match, right?
Yeah, broad. Yeah, as long as any one of those words in your long tail keyword appear, your ad can appear.
Yes, that's going to be your looser, more likely to get response. I mean, not necessarily get what you want. Then there's the what else is there? The other two are the
exact. Like, for example, exact is the most specific, right? I want a bald-headed man. It's got to have I want a bald-headed man in there, right?
Yep.
And then there's phrase match where it says, bald-headed man in there, and as long as those words are in there and they don't have to be in the same order, that ad will show. Now, Google's artificial intelligence and algorithm will also say, well, this person didn't have those words exactly, but they meant it, and then they'll show it. So it's really just something you have to do, and the more data you get, the better off your ad campaigns go, where all of a sudden you have 1,000 negative phrases, for example, that you don't want this thing to show. So it's not a fire and forget media.
You have to spend time on it, and Brad, this is what he does. So you might get a search, like as you're saying, I don't want to become a bald man. So you have to go back in and say, tell Google, like, hey, in the future, don't let this come up anymore. So you create a negative keyword as a result of that. So you have to spend time on it. It takes time, but we find that for most of our clients, we can figure out a strategy that works for them. That gets them the return on the investment that they need from the Google ads.
Yeah,
Um,
and then that's the nice thing. You'll get a report every month, and marketing is it's easy to beat down on the marketer because you have data right there. You can go, it's not working right, and we track it. So the better we track it, the better the client does, and the more they're going to advertise. So we really are big into tracking. And one of those things that related to tracking is the next topic, which is conversion ready landing pages. There's no sense in having great ad campaigns and having pages that are horrible. So John will hit the next
Sorry about
thing.
that.
Yeah. So you want to have a landing page, and John and I will go back and forth on this with designers, et cetera. Because it takes a little bit of work to get a landing page that converts. I mean, when they go to your page, you got to think they have 3 to 5 seconds. They used to say 7. I don't believe it's that long anymore to actually show, all right, this person knows what they're talking about. So you want to have a call to action, call for a free consultation if that's what you do. You want to have testimonials on there. You want to have a phone number, particularly that they can click to call. Form fills should be very concise and enable somebody to fill them out very quickly. And then you want to have those testimonials and success stories, whatever. So you want to do it very quickly and always take a look at what it looks like on a phone, because that is the initial entry for most people to a law firm. It's the phone. And if it looks bad on the phone, then you're probably not going to get as much success, no matter how great your campaign is.
Yeah.
And you can have, look, we've got 2 different campaigns going that are almost similar. And one has a different website name. That's the only thing different. But you can see very drastically how that one underperforms the other one. So the pages are very important.
And yeah, and the other thing, maybe include live chat, maybe also include a video. Just try to simplify the experience. And we're, for the most part, universally, we're creating separate landing pages, separate from the website content pages that you might have an ad just go to. So rather, you could just link your Google ad to the pertinent practice area page, but especially that has a lot of content, especially if they're not necessarily getting that quick, shorter experience. You want to create a landing page instead.
Yeah. Trending topics. This is very useful if you're an attorney that can do something that's related to what's going on. You can very quickly do a campaign, as we've just done over the last month. For 2 different clients, very quickly had campaigns going.
And then
like
turn them off if you don't need them. You
Yeah.
change it. You could be a geographic thing. You turn them on and off. But it's probably more important to have it ready to go. If this is something that you do as a practice area of the law, you don't want to have to sit there and have to create an ad in Google with all the keywords and et cetera. Create a landing page, maybe even create a video or something. Have it ready to go so that you can utilize it when you need it.
Yeah. I mean, I know it's not directly related to law, but public adjusters right now should have everything ready. Go hurricane on, it's that quick, but you have to do it ahead of time, like John was saying.
Yeah, and we do work with a public adjuster, but not in Florida.
No.
But okay. Yeah. Go ahead, Brad.
So performance tracking, right? So you can take the nice thing about Google Ads is you see what real people type. You see that they're looking for an attorney and they might not know how to spell attorney, right? Or they might be looking for a lawyer, but more often than not, they're looking for a lawyer, not attorney. You say you're an attorney, the public's thinking you're a lawyer, but take those actual metrics and the actual keywords and type searches, and you can work them into your website with search engine optimization. So you're paying a little, you're getting very quick feedback, which is good. And then remarketing ads, which is part of almost every campaign we do, is these are people who maybe came to your website either via an ad or just they stumbled upon it. It will target them with ads for a certain period of time after, as they're on different websites, et cetera. And they're like this, they're visual ad type of things.
Yeah.
So,
and whereas we might be spending thousands or $10,000 or more for a client on the search ads, the remarketing, tends to be a much smaller budget, maybe like $500 or so a month, depending on the volume that you're dealing with. So it could be cost effective for some people.
Yeah. Google Video, YouTube, they're out there and they're actually really inexpensive compared to just about everything else out there, TV wise, etc. What happens is people they go into YouTube. If you need to know how to, I don't know, fix a car tire or whatever, you can look on it and somebody did a YouTube video on it, so you can advertise on there and it's not expensive. And if you have a good video, which we could help you with, then you're going to get some business, hopefully.
Yeah.
We talked about the display ads, remarketing is the same type of thing. You've got the TV streaming ads too. I think that was the next thing.
Yeah, I mean the Google Display, what's different, so what's different about the Google Video and the Google Display, and you could also, run these ads on YouTube, is that, the search ads they're going to come up when people search for what your keywords are. Whereas the Google Video Display are going to come up. You're going to use demographic information. You're going to use a geographic area. So they're much cheaper. In fact, we've seen, ads, penny, 2 cents each for some of these things. But they're not, it's more like the billboard sort of advertising. You're looking to, saturate an area or reach people based on the demographic information, not necessarily because they have a need for a lawyer. So that's why they're much cheaper.
So you can target users like Hulu, Pluto, major news networks, smart TVs. It's an easy way to target people now. Some are more expensive than others, but it's an avenue there if you've got it.
Yeah, and Brad, I think something came up this week too. Like what's going to happen is like, Disney Plus and Netflix and other streaming services. They're going to, you're going to be able to target locally over time. Was it Paramount? I think.
Yeah, Paramount. I think I said, yeah, Paramount.
That you could target locally. So over time, like for instance, when TikTok first came along, you really couldn't target geographically very well, and over time, we knew you'd be able to get to, target people based on zip codes and stuff like that, like Facebook does. So it'll take a little time, but you can reach people based on Spotify, Pandora. You can reach them all on a zip code by zip code basis.
Yeah. So I referred to newspapers before. Now, not a lot of people are necessarily reading the printed thing, but they are subscribing and reading it online. Like I'm from New York, obviously. I love reading the New York Times. I used to get the printed paper, but for some reason, they don't want to deliver consistently down in Florida. So now I have to read it on my phone, which I hate, but I get to see the ads. But
Yeah.
and those are one way. So they can inline ads. And so if somebody's scrolling through an article, your ad can appear, and they're not too
Yeah,
expensive.
it's only November through through May or something like that.
Yeah, yeah,
No, just kidding. I don't think that's the
yeah,
case. Um, but yeah, so news websites, social media.
yeah. So you can use targeted ads. We'll talk a little bit more about that with social media. I like to call it largely the junk food of advertising for attorneys. It feels good, but it generally doesn't get you a lot of results.
Yeah, we could go through this quickly because we
Yeah.
could go through it. We have about 5 more minutes, I think.
Yeah.
Some
So
of the-
websites, if you're an attorney, it's probably not a good idea to do it yourself. I've seen them, we've seen them. They're very wordy, and sometimes the layout is not the best. So you want to have a responsive that looks good on a smartphone. Always looks good on a smartphone. That's very important.
yeah,
And
that's
talk
mobile
about
friendly.
yeah, mobile friendly, ADA compliance. Maybe you're one of those attorneys who like suing other attorneys for ADA violations. So you can, make sure it's compliant. It's focused on the client. You don't use too many words that people don't understand. You give multimedia ways of delivering the same information. I like reading stuff. I hate watching long videos, downloadable PDFs. So you want to reach everybody and you want to update it frequently and you want to have an ability to capture the leads. If you live chat, We use Engage with a lot of our clients and those kind of things. Once they come to your site, you've got to hopefully get them to want to do something.
Yep, I talked about that. SEO. I'm just going to run through these quickly.
Yeah.
There's just different SEO techniques, makes a differentiation between on page and off page, which is this is what's on your page, your keywords, your meta tags, et cetera, off page or links, et cetera. So there's you could read through some of this. This is some of the structure, some of the optimization you could do. Content guidelines, have 200 words per page as a minimum. Submit to search engines. Some other techniques here as well. This is just best practices for websites. So
And you'll get all this, so you can read it.
you could so blogs, we could talk briefly about blogs.
You want to make sure you're doing blogs frequently, once or twice a month at least, relevant to what's going on and relevant to what you're doing. And you can post that, slice and dice it, put it on social media, use it in your e-newsletter, your printed newsletter, etc.
Yeah. Yeah, this is important here. The listicles tend to do well. So we've even had some clients have had some listicle type blogs, like top 5 or top 10, and we took them and moved them off the off the blog page and put them on the more general pages, like as quick, easy access on the website because they're so popular. Much popular than even some of the content pages that come up in search engines. Brad mentioned frequently doing the frequency, etc. You post into your social media as well. And we also talked about you can earn media attention with them. So social media, Brad, if you want to go into this real quick.
Yeah, I mean, they're all out there, right? And actually, I saw something we didn't put in TikTok, I think, on this slide, but they tend to skew older. The more they're on there, the people who use them tend to be older. So the young people use it until the older people, which is us now, I guess, are on it, and then they go, I'm moving to something else. But you want to make sure when you're doing it, don't make this your sole focus in either time or money, because it's not going to get you the bang for the buck. Because attorneys, nobody thinks about attorneys every day of the week. Well, we do, but the average person doesn't really like thinking about attorneys, just like they don't like thinking about auto repair shops.
And with that in mind, in this software we have, like on, Hootsuite is one of them, where you create content and post to multiple sites, program it to do so, and schedule it out. So we'll often create a schedule for clients, the month ahead of time, and then we'll program it so they post to different pages. But my suggestion would be, focus on one of these, which will work best for you. So if you're more in business to business type lawyer referrals, then focus on LinkedIn as compared to Facebook and Instagram.
John, I must have missed these. I was looking at the chat, not the Q&A, and somebody had, is Who's Who in America top attorney badge acceptable? That was one question. And the other one was, can an attorney advertise the results of a case that was referred to another attorney? It is advertised a result for the advertising office. The attorney that the case was referred did all of the work and obtained the results.
Yeah, that's an interesting. The second question is interesting. The first one was what again?
Who's Who in America top attorney badge? Is it acceptable?
I mean, listen, you're gonna have to look at the selection criteria. My general presumption on that probably wouldn't be, because it probably is not either objective criteria or peer review. But the rules say it's up to the attorney to look at the selection criteria to see if how they come about it, et cetera, how they determine the rankings. Google My Business, Brad, is kind of important to mention.
Yeah. Make sure your Google My Business, first of all, that you have one. And second thing, if you've been in practice for 10 years and you only have one review, that's a problem. You need to get reviews from clients and have them up there. Because if you don't, you may have the greatest advertising in the world, the greatest website. People are going to check you out on Google and go, no. So you really want to make sure that that's up to date and you're getting reviews. You want to refresh with content, pictures. If you're in the same complex and there's a shopping center nearby and Google just happened to use the shopping center as your office picture, that's a problem. So you want to make sure that it presents the right image.
One of the things with Google reviews, we have some software we utilize, some plugin software that allows you to display your Google reviews, and we could tell it to display you like only 4 and above or over 4, and then people could click on it. It does it for Google and I think Yelp and Facebook reviews that it presents. So it's just one way to put that on your website, keep your website fresh, and presenting your Google reviews right there. When people come to your site.
Yeah.
We just really talked about reviews, trying there's some techniques you could do to try to get reviews, et cetera. But
Yeah.
send them emails, send them text messages, the software that we also use for that. Review removal, there are some cases that we work with clients to help get reviews removed. There's certain criteria for Google, like their spam, their fake content. There's inappropriate material, privacy breaches, et cetera. Maybe there's also conflict of interest that's presented, possibly. So there's certain criteria you could try. Sometimes they'll remove them. One that comes up often, it's maybe a little harder. This person never became a client, but were they in contact with your office? That type of thing. Social media advertising, apologize I'm going over, but I would say use Facebook and Instagram more like billboard advertising in a geographic area. There might be some cases where you could develop some demographic criteria as well, or if you're looking to reach businesses, et cetera. LinkedIn, you could target people by the region, industry, their job role, education, and income. So again, that's something to consider for business to business. TikTok, again, you could target more geographically local areas now as well. We mentioned e-newsletter, turn the advertising label. One thing about unsolicited emails, they're legal as long as you provide an opt-out and as well on a mailing address. One suggestion is try to avoid the spam filters. Use a service like Constant Contact, MailChimp, et cetera. There's others out there. They'll have an easier time getting through. Also consider, like, maybe if you're doing some unsolicited email, I would suggest using a different domain name that your website's on, or I'm sorry, that your regular emails are on, so that like a .com versus a .net. You can integrate with CRMs such as HubSpot or Entreport or others out there. Here's some, we usually see unsolicited emails, 5 to 10% open rates, 20 to 35%, or even up to 50% for known contacts or people that you worked with in the past clients, et cetera. Newsletters and announcement cards, these are still potentially used for to send out. We do newsletters. We recommend like a 4-page 11 by 17. This is some of the content you can include. Announcements we mentioned, events, hold area practice events as well. Host speeches on things in your office. Get involved in the bar associations, CLE programs, as well as in-house. Some other things that we often do for law firms. And just running through this real quick. This was the recent ethic opinions. They're broken down by areas. Just want to make sure that you're aware. This is sort of things that I thought were interesting related to attorney advertising and marketing that they cover some of the main areas. We mentioned lead generation, the Avo case. We're kind of big. This is a non-legal business, the 5.7, 5.8 stuff. Firm names, a bunch of things there, some miscellaneous opinions, etc. Here's our information as well. There's some resources, our information. I saw, Brad, did you see any more chats come up? There's some codes.
No.
Any Q&A? Okay, just looking at it right now. All right, so
yeah, and if anyone has a question, they can send it to me. I will gladly forward it, or you have their direct email. So
we didn't lose that many. We only lost about 10% after we went over, so that's pretty good.
Yeah, no, it was very good. I just wanted to thank you both for a great presentation. Like I said, everyone, I will be resending all of the information, the evaluation, the affirmation, and the materials to everyone again this afternoon, just in case you didn't have it. Thank you so much. It was a great lecture, very, very interesting, and hope everything goes well with you, Brad, with the weather.
Thank you. So do I.
And then, yeah, our contact information is here. The person had a question. That's our email addresses, and phone numbers. I hope I have left it up long enough, but feel free to reach out to us if you have any questions.
Thanks,
All
everyone.
right.
Thank
Thank
you.
you.